My name's Michael Bedford. I'm Queen's Counsel, and I'm very pleased to be joined by Ruchi Parekh, one of our very successful junior barristers, who is here to help on a variety of infrastructure matters. I should also mention that Estelle Dehon, who I think appeared on the initial promotional material, was hoping to join us, but unfortunately she's unable to do so because of various family commitments in South Africa. But she did send her apologies, and hopefully we'll be able to fill the gaps that Estelle would have no doubt insightfully dealt with during the presentation. I think we've got, just as a bit of, as it were, PR, there are some other upcoming webinars which you may have seen, and some of you may indeed have participated in the local plans webinar last Monday, and obviously if any of these topics are of interest to you, we've tried to deal with some as well current hot potatoes. Please book, there are places still available. And whilst I'm in, as it were, salesman mode, I'll also just briefly mention that those of you who look at our website will have seen that the spring edition of the Cornerstone Development Quarterly is now available, and you can download that for free from the Chamber's website, including an article from Ruchi, so there'll be something else for you to get to grips with. And also, as a final piece of puff, I'll mention that the second edition of Cornerstone on the Planning Court was published last month by Bloomsbury Professional, and you can order that. Unfortunately, that's not available free, but that provides an update to the first edition on the work of the Planning Court. So then moving to today's session, and we've split it into two. First of all, you're going to unfortunately have to hear from me, and then things will ease up because you'll be able to hear from Ruchi. And I'm dealing with the topics on the this first slide, and essentially I'm looking at some broad topics in relation to the way that the Planning Act 2008 regime works. And then in the second part, Ruchi is going to be looking at some of the specific parts of the process directly relevant to local authorities. And we're also intending to have a Q&A session at the end after both of our presentations, which hopefully, if you can use the Q&A function on your Zoom screens, if you want to, at any stage, type in your question. And don't feel you have to wait till the end before you type your question in, but if you do that, we'll try and pick those up, or as many of them as we can, at the end. Generally, what we're trying to look at are matters from the perspective of a local authority when dealing with the 2008 Act regime, and that's whether as the regulating authority, with somebody else's project taking place in your area, or it may be that you are actually promoting a 2008 Act project probably in your area. And so we're looking at both of those. In terms of the tone, as it were, I've noted from the list of attendees that there is a range of people, some of whom are incredibly familiar with the DCO regime, and I hope that what we say won't be too much like teaching grandmothers to suck eggs, and some of you will be perhaps less familiar with the regime, but wanting to just make sure that you're up to speed or up to date. So turning to the basics, and the first straightforward question, because it is a bit of a jargon-laden world, what are NSIPs and what are DCOs, and what's the difference? Because you will hear both phrases or acronyms used enormously. And very simply, a nationally significant infrastructure project is the actual scheme of works which are being proposed, whether that's the new road, a wind farm, a power line, rail link, or a freight interchange. There are also what I've called quasi-NSIPs, which we'll come on to, but that's a later joy. Whereas the development consent order, the DCO, that is the statutory instrument that authorises the scheme of works, and it sets out not only the authorisation as to what can be done, it will include other powers as necessary, for example, compulsory acquisition, traffic orders, deemed marine licenses, etc. So that once you've got your development consent order, for the most part, you're then ready to implement your project. Then national policy statements, that's the other key ingredient that you need to understand. The National Planning Policy Framework does not address NSIP projects, as it says in paragraph 5, that's not its purpose, albeit that the content of the NPPF may be relevant to a particular project. So it's not that it's irrelevant, it's just that it's not intended directly to address NSIP development. And that's because NSIPs are subject to the national policy statements for the subject matter in question. So there are a suite of national policy statements dealing with energy, dealing with transport, dealing with waste, dealing with water, and indeed dealing with wastewater. The NPSs are produced by the relevant Secretary of State for the subject matter, that's say the department in question, so that the transport NPSs are produced by the Department for Transport, whereas the energy NPSs are produced by BEIS. They are subject to parliamentary debate before they are formally and finally published, which gives a degree of parliamentary oversight, but the Secretary of State has to take into account the recommendations of Parliament, but not necessarily agree with those. Once they're published, they stand until they're formally reviewed. And unlike the TCPA world, where there are frequent arguments as to whether or not a policy is up to date or out of date, both at a national level and at a local level, that is not a feature of the 2008 regime, and Mr. Justice Holgate's decision in the Client Earth litigation makes that point clear. And that essentially once they're published, they stand, they are to be applied, and there's a separate mechanism for their review, and that process takes place outside of individual examinations. And so an examining authority in an individual examination should not be exploring, is the NPS still up to date? Notwithstanding that, arguments about that do still surface in examinations. Where there is a national policy statement for the subject matter of the project, then they are to be followed, i.e. the decision should be made in accordance with the national policy statement, with only limited exceptions as set out in section 104 of the Act. Essentially, if to follow the NPS would put the decision maker in breach of an international obligation, in breach of a statutory duty, otherwise acting unlawfully, or it is concluded that the adverse impacts of the development outweigh its benefits. Those are reasons when the NPS need not be followed, but otherwise they're expected to be followed. If there is no relevant NPS for the project in question, then the decision maker has to take into account important and relevant considerations, including the local impact report, which Ruchi will tell you about, but obviously they're not directly constrained by the NPS. Having said that, and as a particular issue which arises in relation to the energy NPSs, the energy NPSs are still current, albeit that they are being reviewed, but the energy MPS, which relates to nuclear, was specifically worded to only apply to projects which were likely to take effect by 2025. So, for example, the Sizewell C project, which is just starting its examination, it started last week, albeit that there is an energy MPS EN1 which is applicable and EN6 is applicable, they are not directly to be applied because of that, as it were, that timing provision. So they are effectively material considerations in the process rather than determining considerations. So what is it about the DCO regime which are its fundamentals? Well, you don't make an application to the local authority, potentially have it refused and then appeal. You make your application direct to the relevant Secretary of State for the NSIP subject matter, so whether that's BAYS, DFT, DEFRA, or potentially MHCLG. It's intended to be, broadly speaking, a one-stop shop approach, i.e. you don't just need or use the DCO to get your planning permission. You can also get all sorts of other consents, whether that's in relation to listed building consent, whether that's in relation to a marine license, whether that's in relation to traffic orders, stoppings up, and importantly, compulsory acquisition. It can all be dealt with under the one roof. There is very significant front loading prior to the application actually being submitted, specifically the consultation stage, which those local authorities who've been involved with DCO projects in their area will know about, is a significant matter pre-application in terms of not only consultation with statutory bodies and local authorities, but also with local communities. And similarly with environmental assessment, there is a requirement as part of the consultation process to provide preliminary environmental information. And then there is a scoping exercise, again pre-application, on the content of the environmental statement if your project requires environmental assessment. Most or inevitably do because of the scale of what we're talking about. So all of that has to happen before your application is ready to be submitted. Once you've got everything ready, your application is submitted. The planning inspectorate has 28 days for acceptance of the application. That simply means it's fit to be examined. It doesn't mean that it's acceptable in the sense that it will be granted, but it's not a rubber stamp, as was recently found by Highways England in relation to the Lower Thames crossing, which they submitted for acceptance last autumn to the planning inspectorate. There were significant representations made by local authorities about the adequacy, or more particularly the inadequacy, of the consultation as they saw it. That led to PINS contacting the promoters, Highways England, for an explanation and, as it were, further information. It became clear that PINS was not reassured by what it was told. It then intimated that it was minded to not accept the application as fit for examination, and seeing therefore the writing on the wall, Highways England withdrew the application from the planning inspectorate shortly before the acceptance decision was due to be made, and it is now in the process of regrouping and reworking matters so that it can resubmit its application, hopefully in a form that it can be accepted for examination. The other point to arise after acceptance, there is what I've called limbo land, which is to say there is a period after a project has been accepted but before the examination starts, which is unspecified as to what its duration may need to be. Typically it's 3 to 6 months. It can be longer, it's rarely shorter, but in that period effectively the clock is not running, but things are happening, as it were, behind the scenes, and the planning inspectorate is arranging to hold a preliminary meeting to deal with the procedural ways in which the examination will be undertaken, but the actual examination doesn't start until the end of the preliminary meeting. That's important because once the examination starts, there is a clock running. The 6 months period for examination is set by the statute. Extensions are rare, albeit now not, as it were, unprecedented. And many of you will know that the East Anglia 1 North and East Anglia 2 offshore wind farms have recently had an extension. And last year, the Norfolk Boreas wind farm was also similarly extended. And in part, those extensions have been to enable the examining authority and participants to deal with COVID matters. And sometimes it's been to deal with matters in terms of further information, particularly in terms of ecological information. But basically, it's a 6-month examination. It's a short period. It's a 3-month report stage for the examining authority, and then their report is provided to the Secretary of State, who has a 3-month decision stage. Whilst the Secretary of State can vary those time limits and can extend the decision stage, and sometimes does, they have to make a statement to Parliament to explain why that is the case. And so although, again, extensions are not unheard of, they are rare. The process, and this is quite significant to those of you that come at this more from a TCPA, as it were, background, it is very largely a written process. Participants get involved by making a relevant representation during the registration period, which is a minimum of 28 days, but it can be longer if that is thought appropriate. The examining authority sets firm deadlines for the timetable for the examination as to when things have to happen, and it will be strict in applying those deadlines. At an early deadline in the process, the parties will be required, or at least given the opportunity, to submit a written representation. Host authorities are invited to submit a local impact report. Ruchi is going to say a little bit more about local impact reports in due course. The examining authority then asks rounds of written questions, either to all participants or to specific participants seeking answers to things they want to know more about. And then there can be comments on those responses to those written questions. And hearings, again, Ruchi will say something more about the different types of hearings, but the hearings are essentially limited, they're focused, and they're inquisitorial, let's say, led by the examining authority, with cross-examination being the exception and not the norm. And so the important point for those less familiar with the regime to understand is it is quite wrong to adopt engagement with the DCO process with the mindset of, oh yes, well, we won't need to really, as it were, marshal our arguments and our evidence until the hearing stages, because that's not right. You have to marshal your arguments and your evidence. You marshal your basic arguments in your relevant representation, and then you marshal your evidence in your written representation. I say you don't approach it on the basis of thinking, oh well, we can get round to it. You won't have that opportunity, and you may get a dusty response from the examining authority if you seem to be introducing new points during the course of the examination. So DCOs are attractive to promoters. I think Ruchi's just about to move us on. Because there is, generally speaking, a predictable timescale. There is the one-stop shop option, albeit it should be noted, not everything. So, for example, at Sizewell C, the nuclear site license, which is to be obtained from the Office for Nuclear Regulation, that is sitting outside of the DCO process and won't happen until effectively the DCO process is over. So it's not invariable that everything will be dealt with under the DCO, but predominantly it is. It's also the case that generally the outcome of a DCO exercise is predictable, but not always. I mean, they do have a high track record of success, but there are some notable exceptions to that. They tend to be wind farms, both offshore and onshore. Navitus Bay back in 2015, that was off the south coast of England, Dorset and Hampshire and the Isle of Wight. Menethu Gwent onshore wind farm in Powys, that was in 2015, and then the Thanet extension offshore wind farm off the Kent coast, that was 2020, last year. Those were all cases where the relevant Secretary of State was not persuaded of the arguments of the promoters, and so the applications failed. But for the most part, they succeed. There is high caliber examining authorities. There's a panel of inspectors who are, I say, good, expert, and so you get robust and good quality decisions, which is a probable reason for the high success rate. They probe and they improve applications. So there's a lower risk of successful legal challenge, which makes it obviously both commercially and project attractive to those promoting. But there are legal challenges which have succeeded. Obviously, Norfolk Vanguard is a recent quashed decision, quashed on the grounds, not of anything that the applicants appeared to have done wrong in terms of the way that they presented information to the examining authority, but it seems more due to a shortcut that the examining authority took in their approach to cumulative impact assessment, which wasn't then picked up by the Secretary of State, and that led to a successful quashing by the High Court. And then the Manston freight terminal facility at the former airport in Kent, that has been quashed by consent. That attracted from the examining authority a recommendation against. The Secretary of State decided he wanted to disagree with that proposed grant, so did, but that was challenged on the basis of inadequate reasons, and the Secretary of State has conceded to that challenge, so it's going to have to be redetermined. So then I was going to turn to this question about NSIPs and quasi-NSIPs. What are they? Well, NSIPs themselves, schemes that can be put forward as NSIPs, they're defined in the 2008 Act together with some secondary legislation. Section 14 sets out the broad categories. They are effectively all things that you might call infrastructure in its, as it were, its old-fashioned sense, not in the SIL regulation sense, which is rather wider. So it is things like roads, it is things like power lines, it is things like waste facilities, and so on. And Part 3 of the Act sets out the detailed parameters for things which fall within those categories, which the Secretary of State is either able to add to or remove from. And the parameters can be size in terms of land take or length, it can be capacity, particularly with terms of energy generation, or they can be promoter focus. Let's say who's the operator going to be, so that, for example, with road schemes, Highways England, which is the obviously the strategic road authority, has a role. Its projects fall within the NSIP regime, but an equivalent project promoted by a local highway authority would not do so because the road in question would not then be operated by Highways England. Then quasi-NSIPs, that's not a term of art, it's not a term I think that's used directly in the legislation or in the guidance, but Section 35 of the Act allows the Secretary of State to direct that something which isn't an NSIP can be what is called a project of national significance. Perhaps for understandable reasons, the acronym PONCE is not widely used. But if the Secretary of State thinks that it should be a project brought into that regime, and it's in one of the categories in Section 14, or it's business or commercial development, but not residential development, then he can make a Section 35 direction. Once he does so, that then means that the project can only be authorised by a development consent order, and the procedure for securing that DCO is the same as for a conventional NSIP. Then some examples of NSIPs, sorry, quasi-NSIPs. The Norwich Northern Distributor Road, the Great Yarmouth Third River Crossing, both promoted by Norfolk County Council, the Lake Lothing Third Crossing by Suffolk County Council, the International Advanced Manufacturing Plant adjacent to the Nissan plant in Sunderland. On the slide, it only refers to Sunderland City Council. That was more for reasons of brevity and not wanting to mess up the slides, because clearly South Tyneside Council is also closely involved in that project. And that's slightly unusual. The application has not yet been submitted, but there were two Section 35 directions, an original one back in 2015, and then a variation in 2017, because the urgency of that project was such that it became practical to see part of it proceed under the TCPA Act regime so it could get underway more quickly. And so the Secretary of State effectively varied the Section 35 direction to allow that. Then there's London Resort, which is the private sector entertainment complex promoted on the North Kent shores, and the DCO application has been accepted by the Planning Inspectorate, and it's now in limbo land awaiting its preliminary meeting, with a examination expected probably during the remainder of this year. Just a little bit more to give you a bit more flesh on Section 35 directions, because those of you from a county council or a unitary authority perspective may be thinking, well, is the DCO world the world for us with our highway projects? And so I'll just briefly touch on three which I was involved in with both Suffolk County Council and Norfolk County Council. The Northern Distributor Road at Norwich, a 22-kilometre dual carriageway linking the A47 trunk road to the Norwich International Airport, and then strategic road routes to and around Norfolk, and also supporting the growth of Greater Norwich. The Secretary of State was persuaded that that was nationally significant, albeit that it was a local authority highway scheme, so brought that into the DCO regime. That was authorised, and it has been constructed. And for those of you familiar with navigating your way around Norwich, it's a great boon. The Great Yarmouth Third River Crossing, a new lifting bridge to allow the Port of Great Yarmouth, which is an operating base for wind farm developments out in the North Sea, better access to the A47, and also helping to regenerate the town. Construction on that project is getting underway, with early works now commencing. And then the Lake Lothing Third Crossing, that is a lifting bridge bypassing a bottleneck. For those of you familiar with Lowestoft, on the A47/A12, the Bascule Bridge, that funny thing that you have to crawl across at bad times if you get the traffic wrong. And so a new bridge will be provided. Improved access for the Port of Lowestoft, which also has a wind farm role, together with regeneration benefits, particularly to the south shore of Lake Lothing. So they're both effectively transport benefits, which were wider than merely local matters. Wind farm benefits, improving access to facilities that would help with the development of offshore wind farms, as well as regeneration benefits, saw those brought into the DCO regime. Then regeneration schemes There's less information on those. Obviously, the International Advanced Manufacturing Plant, although it's a greenfield site, I mean, I think you can see it as regeneration in a wider regional sense. It's the major development north of the Nissan plant at Sunderland. It will be providing significant employment, 4,700, 4,800 direct new jobs, plus the indirect and supply chain benefits that development will bring about. I'd say the third river crossing at Great Yarmouth does help regenerate a rundown quarter of the town, and Lake Lothing similarly helping to attract inward investment. And those of you who've driven around the south side of Lake Lothing will know that there is a great deal of, as it were, land there which is potential as a development opportunity, but perhaps suffers from a lack of accessibility, or at least attractiveness to the market at present. So there are things which I say you can bring forward as a local authority, and it is worth looking closely at whether Section 35 would fit your project, because if so, you can get the benefits of the DCO regime in terms of that structured and streamlined timetable, and you can bring yourself within it. So then, coastal authorities, if I can move on to those just briefly, Section 56A identifies the local authorities who are the hosts. They will be invited to submit a local impact report. It's a geographic basis looking at the land within the DCO application. Unitaries, counties and districts can all be host authorities if it's happening in their patch. And just one point to note, something which has arisen in the Sizewell examination, the applicant has recently put forward changes to the mitigation, amongst other things, works, which include adding some land, some 40 miles from, no, 40 kilometres, I think it is, from the main Sizewell site as a fen meadow mitigation replacement facility. And so that has brought West Suffolk Council into the frame as a new host authority, when they would not otherwise be so, because West Suffolk is some distance from the Sizewell site. So I'm now going to hand over to Ruchi, who will take us further forward. Thank you.
Great, thanks, Michael. So I'm going to pick up where Michael left off, basically, and deal with the 4 topics listed there. So looking at adequacy of consultation, local impact reports, participation, and a sort of post-consent discharge of requirements. And at the end, we'll leave a little bit of time for questions, as Michael indicated. So starting then with adequacy of consultation, the focus here is very much on community consultation, as distinct from any the local authority itself being consulted on the application proposals. And the starting point here is that under Section 47, the applicant has a duty to prepare a statement setting out how they propose to consult with the community. And this is known as the Statement of Community Consultation. And essentially, the local authority will play a key role in ensuring best practices as regards consultation are followed. And you will be involved at 2 different stages, pre-application and acceptance. So looking first at pre-application stage, as I mentioned, the first document that you will be consulted on will be that Statement of Community Consultation, and the applicant must give you, under the statute, 28 days to consult. The reality is that all these timelines, as Michael has indicated, are quite short, and actually in practice, or rather best practice, as with everything in the NSIP process, is to engage early on any given topic or document, and it's often, can be an iterative process rather than waiting until the, the day that it's formally submitted to you for consultation. So as I say, the local authority will be consulted, and then once you send in your response, effectively the applicant has a duty to have regard to the response when finalising their draft statement. That doesn't mean that they have to follow everything that you've said, but they must have regard to it. And I'll come on to kind of the issues that arise when they haven't really taken on the points that you may have put in your consultation response. In terms of content and what you think, what you should be thinking about when responding, well, an obvious starting point here is to look at your statement of community involvement. And so, you know, it's unlikely that you can just apply sort of in a blanket way what you've got in that document, but certainly you can take your principles, etc., and tailor them to the project at hand. Then the next thing, and this is really crucial, is to think about local circumstances. Now, as the local authority, you will be best placed to know about the nature of your community and, you know, appropriate geographical spread, etc. So you might, you know, you will be best placed rather to know whether any particular groups will be disproportionately affected by the proposals. For example, you know, either disabled persons or retired people or commuters or children going to school, etc. So those are things that you can, you know, sort of take into account when responding. And the other thing is digital exclusion, and that's something that you do need to be mindful of, particularly in this you know, post-COVID world that we're living in. So there will be certain persons or groups of people within your community who may well be digitally excluded, and so you will need to flag that as an issue and also ensure that the developer has properly addressed those points when it comes to consultation. And then for all of these points that I've just mentioned, it's often a good idea to get early involvement from your parish or community council to inform what you're saying is a matter of best practice. The final thing then is just thinking about the duration or proposed duration of consultation. So often what you have with these large projects are multi-stage, you know, many stages to the consultation process. So you want to be thinking about, you know, sort of inbuilt flexibility within that to account for sort of changing circumstances over a long period of time. You might also want to just be mindful that often if there's a large delay between when they've prepared that statement and when they actually start to consult, you know, whether anything has materially changed on the ground and whether you need to bring that to the attention of the applicant. So that's at the pre-application stage. The next stage that is in which local authorities will play a crucial role is, oh, hang on, sorry, it's gone up, is at the acceptance stage. Now, as soon as the project is formally submitted for acceptance, the examining authority has a 28-day period within which it has to make a decision. And within that timeline, what the examining authority will do is it will invite the local authorities to submit what is effectively known as an adequacy of consultation representation. So you have 14 days, which is an extremely tight turnaround. And in order to meet this timetable, we would, you know, advise you to think about a lot of the issues in advance. So first of all, have in place any appropriate internal approval mechanism that you need before you can, you know, send off or submit documents. The other thing that you might want to think about is keeping a working log of any complaints or concerns that are raised by the public during the actual consultation process. As the local authority, you will often be the first port of call when, you know, and the examining authority, the PINs in fact will direct individuals to raise any complaints with the local authority. So it would be helpful to keep a log as you go along. And then of course have also a document ready sort of from an early stage, outlining any issues you think there is with the methodology that the applicant has proposed. So, for example, in your consultation response, you might have suggested best practices or certain tweaks to methodology, which the applicant may not have taken on board. And certainly those are things that you can prepare, you know, in advance. And if you think that the methodology that was adopted was inadequate for whatever reason, you can have those sorts of issues sort of ready to go in advance of the sort of formal 14-day period. In terms of the statutory requirements that must be that you must turn your mind to in the adequacy of consultation representation, those are the 3 bullet points that I've set out on this slide. Effectively, you need to address the examining authority on whether the applicant has complied with 3 things, and that is the statutory duties as regards consultation and publication, then the duty to consult local authorities about the draft statement of community consultation, and then ultimately whether they have in fact complied with the commitments that they set out in their statement. All right, turning then to local impact reports. Now, this really is a key document which both the examining authority and the Secretary of State must have regard to when making their decision. And BINS very much encourages local authorities to produce local impact reports, because they do gain assistance from the local authority's perspective. So that's very much encouraged. In terms of timetable, what will happen is that effectively the local authority will receive an invitation, a notice of invitation post acceptance. But again, as I've stated previously, our advice is to make the most of the pre-application stage. So really very early on, you can start assessing the impact of the proposals on sort of local conditions. And the earlier you do this, well, it helps in two ways. Firstly, again, there'll be a tight timetable that you'll have to meet once the proposals, the application has been accepted. But also the earlier you assess impacts, the more likely you are to be able to apply your mind to what will be best consultation practices, because if you know that certain things are going to impact more strongly on certain groups or certain geographical areas, you can you can feed that into your consultation response. And like with the previous topic, again, just make sure you have internal authorization processes in place so that that doesn't, the sign off, etc., from the relevant person at the council doesn't delay you in making your submissions. In terms of content then, there's a very brief definition in the Act, and I've set that out on this slide. And really, it's for the local authority to comment on what it thinks will be relevant topics or issues, and how you think those are going to be impacted. That being said, BINS does have a series of very helpful advice notes on its website, and one is directed specifically at local authorities and the drafting of local impact reports. And these are some of the issues or topics that BINS recommends it would be helpful to have the local authority's perspective on. That being said, bear in mind this isn't an exhaustive list, nor is it prescriptive. So of course, you will be best placed to judge what you need to talk about and what you need to flag for BINS's attention. I think from my own experience, I think what is most helpful to the examining authority is if you're able to draw on your existing local knowledge and experience, what impacts you think will have. So for example, local evidence of flooding, or if particular commuter patterns that are very specific to the area that you're looking at, or local social and economic issues. But what is not necessarily helpful is for the local authority in its local impact report to go into any sort of balancing exercise, because of course ultimately the decision is for the examining authority and the Secretary of State, having regard to the local impact report. Just a few things to bear in mind when you're preparing that. It is helpful and probably required to, just to have at each stage a statement of what you think are the positive, neutral and negative impacts. I think the examining authority find it quite useful to know, even if your answer ultimately is that you're neutral on this, or you have no comments to make, or you don't think it needs to be improved, etc., that is helpful to have in writing for the local authority. And as I said, draw on your local knowledge. So it is helpful to have your assessment of what the relative importance of different considerations are and what likely impact the proposal will have on it. Right, moving on then. I am going to talk next about the actual DCO examination process. And as Michael has said a bit about this already, and as he said, this is a 6-month process, although of course there will be the rare circumstance in which you might get an extension. Now, the reality is that this is a very highly resource intensive period, which is why we have emphasized to try and get as much prepared or agreed in advance of the formal 6-month process. It is also largely a written process, as Michael has indicated, with hearings providing very much a supplemental role. One thing I perhaps haven't mentioned so far is that prior to the formal DCO 6-month process, what the examining authority will arrange is a preliminary meeting, and that's actually right at the start. It will then set out a timetable for how the proposals will be examined and how the examination process will run, and it will set out a series of deadlines, etc., which will help inform you as the local authority how best to prepare. So at that stage, really, once you have an indication of how things are going to play out, it's a really good idea to get a strong team together, lay out some sort of, just basic best practices, etc., of how the team will engage, how document sharing will work, and just the practicalities of what can be, as I say, a very resource intensive, but also very document heavy process. So getting all these things in order before you really kick off is a good idea, because it should make the rest of the process a bit smoother. So I'll just look very quickly at the two elements, starting with the written process. Some of these documents we've covered already, so the local impact report, which comes very early on, the statement of common ground. Again, this really should be something that you're encouraged to work on with the applicant from the pre-application stage, and the examining authority finds it very helpful because it does help them to narrow down on the issues that they really need to be working on. That being said, just because you and the applicant have agreed on something doesn't mean that the examining authority will never ask questions or probe further into why agreement has been reached. But that's something that we encourage you to work on early as possible. Michael has mentioned relevant representations, which also come at an early stage. And so then what happens really during the 6-month process is that there will, as Michael has said and I have said, there'll be a series of opportunities and rather deadlines where you will be providing more written evidence to the examination, and this will take various forms. So it will either be sort of your own position at various stages depending on how things have moved on. You will also be commenting on the written representations of other parties, in particular the applicant. You will also be responding to the formal written questions that the examining authority will set. This will either be one or more sets of written questions, and almost certainly some of the questions will be directed to local authorities. And then finally, you will need to scrutinise the plans that are being put forward to ensure that if this project is consented, then of course you have the best possible outcome in terms of construction practices or environmental management, etc. Moving on then to the hearings, there are different types of hearings. So just very quickly, open floor hearings are more community focused. This is where individuals can come along and talk about what they think the issues are, and what, for example, if the examining authority has set out what issues they'll be considering, if people, particularly the local community, want to come along and say, actually, hang on, we think we'll also be affected in X way or Y way. And my experience so far is that local authorities aren't necessarily playing a key role in these kind of hearings, but where you will play a key role is if you have land that is likely to be subject to compulsory acquisition. So this won't always apply, but if it does, of course, you'll need to work again with your property team and make sure that you've got comments and assist the examining authority when you get to those hearings. And then the most important set of hearings are the issue-specific hearings, which Michael mentioned. Now, these will usually be arranged by topic. Sometimes, very rarely, will be done sort of based on specific sites. But this is really your opportunity to go along and make representations on what you think, how the key issues, for example, highways or flooding, how they've been dealt with, really. By the applicant, and whether you think that the applicant's evidence is deficient in some way, or whether it needs to be improved, or their modelling is wrong and why you think it's wrong, for example. So the one particular hearing that I've highlighted on this slide is the hearing on the draft DCO. And the reason I've highlighted this one in particular is because if the project is consented, there will be lots of key obligations or requirements, i.e. conditions in the DCO that ultimately you as the local authority will be responsible for in terms of discharge. So you do really need to ensure that the way everything is drafted is deliverable and is consistent. And you might want to, be mindful of various factors when you're looking at the draft requirements. Say, for example, time limits. You might want to also have a think about how it's been drafted in terms of consequences of non-determination, because there are different models. Say, for example, the applicant might have adopted a model where if you don't determine within a time, it may lead to default consent, and that's something you need to be quite mindful of. In my experience, particularly where you're concerned as a legal authority that actually even post-consent you're going to have an awful lot to do and lots to think about, it is helpful to get some sort of agreement with the applicant that you will follow an iterative process when it comes to the discharge of requirements as well, so that you'll have sight of the applications and work alongside them prior to having the formal determination period kick off. And certainly in the East Anglia wind farm projects that Michael mentioned, this was kind of pursued through a planning performance agreement with the applicant. And so that's one, sort of practical way that you can think about these things. And as my final topic then, that is the post-consent discharge of requirements. I've talked about some of the practicalities at the, when you're actually examining the draft DCO. And really, I think, not to be the bearer of bad news, but the reality is that while the DCO process is very resource intensive, actually the post-consent process, particularly around discharge applications, can also be equally resource intensive. And so again, much like what we were saying early on, this is another, another period in which you need to be mindful of time limits. Many requirements might require you to consult with other parties, or other statutory bodies, or other local authorities, in fact. So you need to think about, again, just setting up best practices at an early stage, how you might document share, things like that. And then as a final point, in terms of enforcement, I've got a list of things on the slide. I'm not going to go into detail into each one because I'm mindful that we're coming close to the end of the hour. But just to flag that in terms of website prosecution, the key thing here is that it is essentially a criminal offence to carry out development in breach of the terms of the DCO without reasonable cause, or without reasonable excuse, rather. And so the applicant, if that does happen, they are liable to be prosecuted. The local authority also has particular powers when it comes to where an offence is suspected. So you have rights of entry, you also have the power to require information within a certain period of time, and then ultimately you have the power to obtain an injunction where you think it's necessary or expedient in order to apprehend a potential breach. So I think, bearing in mind the time, I think I will stop there and open it up to questions. I know I've been fairly quick with a lot of the stuff that I've mentioned, but hopefully if you use your Q&A button, and you may well have done already, if not had a look yet, this is really a chance to ask us in a bit more detail about some of the many topics that we've tried to cover in this hour.
Thank you, Ruchi. That's very good. Yes, we have got one question which I'll deal with now, because I've had the opportunity to look at it whilst you've been speaking, and somebody's asked the question, is there provision for legal representation of the parties at all, or any of the hearings? To which the answer is, well, yes, in that there is no preclusion on legal representation, and it works in a sense in the same way that local plan examinations work, which is to say there is no requirement for parties to be legally represented, but custom and practice has shown that many parties prefer to be so. It's although, as I said, there is very rarely any question of cross-examination of witnesses and the giving of evidence in that kind of inquiry style, because that really just doesn't happen. Nonetheless, many participants feel that whilst they have people with technical expertise, they prefer to have somebody who, as it were, spends their life speaking in public to be their mouthpiece. So people like Ruchi and me do participate actively at hearing sessions. And again, I think the examining authority, there was, I think, possibly some hesitancy initially as to whether they were welcoming the lawyers, as it were, getting stuck in to their process. But I think they've realised that actually one of the things that we are hopefully able to do is to bring an element of clarity, distillation, and critical insight to matters, which actually can help the examining authority focusing on the key issues. And also, not that this is particularly a legal minefield, but there are occasions during the course of that examination when an issue of law does arise, and obviously if you've got your lawyers available, then they can help deal with that matter. So yes, we do appear, and legal representation can be beneficial, albeit I should say it's not something that is necessarily required. Then in terms of, we've got a question which is, do you have any indication of the typical numbers of NSIPs likely to be dealt with by a medium-sized local authority, e.g. once every 5 to 10 years? Well, I'm afraid the answer isn't as simple as that, because they're project specific. It depends which part of the country you're in. And if you look on the very helpful National Infrastructure website, effectively it's the PINS website dealing with national infrastructure projects. You can search projects, and you can search them not only by name, but also there's a map base. And if you look at them, you can see that, for example, because clearly there is a government drive to do with obviously net zero on renewable energy. So offshore wind farms are a big issue at the moment. So clearly, if you are an authority which is effectively a coastal authority, so whether you're Norfolk, whether you're Suffolk, whether you're the west coast of England, you're one of the Welsh coastal authorities, less so on the south coast at the moment, although Kent has received a number of applications, then you will be receiving a lot of applications. And I know that certainly on the east coast, they are not only receiving currently applications, they've got, as it were, a pipeline of applications. Whereas if you're a small authority, somewhat remote from the coast, then you might not be affected by a wind farm proposal, because you know the government is lukewarm about onshore wind farms. But you may very well be affected by one of the very large number of Highways England DCO projects improving the national road network. And again, if you look on the PINS website, you can see, because they not only tell you which projects are actually on the books now, they also tell you which projects that they have been contacted about, which are expected projects. So if you haven't had experience yet, you may very well find that inspection of the National Infrastructure website tells you that something's coming down the line to you fairly soon. Then just in terms of other questions, we've got question, we are co-hosting an NSIP at pre-app stage. Do you have any advice on resource sharing between LPAs? We are exploring this, but mindful of issues of probity, sovereignty, etc. Thank you. Well, yes, I mean, that's absolutely spot on. You do need to have a good think about the issues that are of importance to you as a local authority and to your neighbouring or overlapping local authorities. And you have to, you know, in a sense, be pragmatic, but also be realistic. Are you likely to be on the same page on the various topics and impacts that arise, or potentially are you likely to diverge because the interests of, let's say, your members in terms of the mitigation that they regard as the most important may differ from that of your neighbouring or higher tier or lower tier authorities' interests. And so you may need separate representation in terms of how you deal with matters, and separate consultants to advise you on matters. On the other hand, you may very well find that you can share a lot of resource, and you may, in a sense, play to your strengths. I mean, certainly in terms of the offshore wind farms that both Ruchi and I have been helping Suffolk County Council with, for formal reasons, they don't have entirely the same view as East Suffolk Council on issues, on all issues, but they have been both at officer and at legal level sharing information, so that, for example, landscape, which is a matter particularly being dealt with by East Suffolk Council, is not therefore dealt with by the County Council, whereas conversely highways, clearly you would have expected the highway authority to be more involved. So yes, and I can see that again, my point about the issue of whether you get a DCO or you don't, they are a bit like buses. You wait ages and ages, you get very little, and then all of a sudden you'll get inundated. And obviously that goes to the whole point about institutional experience. It's helpful if you've got somebody within your planning and environmental teams who's at least been through the ropes, because they can share that experience. But again, if you haven't, the other thing which is worth noting for those who are, as it were, unfamiliar with the process, is that certainly the DCO hearings are all recorded, and you can access those, and if you have time available, you can play back sections of those to see what goes on. The Planning Inspectorate has also recently introduced a transcript service, but because it's not, as it were, a human transcript, it's artificial intelligence, you have to read it with a pinch of salt, because particularly in a very much a jargon-laden world, the AI misspells or mispronounces all sorts of things. Some of the typos are quite hilarious, some are almost bordering on the offensive, but nonetheless that's a very good way of sort of getting a bit of an inline as to what is going on. And I think so the wider point is that if you do have either in your area or in a neighbouring area a DCO going on, and you've got the time available, you can pop into one of their sessions. You only have to be there for part of the time just to get the flavour of it. Obviously, COVID at the moment means that sessions are currently being dealt with remotely, but as we move forward into the summer, there is certainly a desire by PINS to get back to having some live events, and indeed some blended events, as we're now being learnt to term them. Okay, I think, is that all of the current questions? I think that looks like everything. Let's just see. Yes, I think I've got those all. Yep, I think that's it. I think we are now just over time. So, Ruchi, is there anything else you wanted to add in terms of any of those points?
No, I don't think so. No, I think you've covered it all.
Okay, well, thank you very much. Thank you, Ruchi, for your contribution, and thank you all for those who stayed with us, and hopefully we've at least whetted your appetite to learn more about the world of DCO. And it's like most of these things, once you're familiar with it, then it's actually perfectly straightforward and manageable. But there is a little bit of a feeling of, oh, well, I'm unfamiliar with it, I'll just stick with what I know, sort of thing. But as I say, I think it's very much a case of once you've had experience, you realise that it's like everything else, and local authorities can actively participate in the DCO process, And particularly, I say highway authorities can certainly think about it in terms of promoting highway projects, and it's a very useful vehicle, as both Norfolk and Suffolk County Council have found very much to their benefit. So thank you very much, and thank you also for those who've indicated their thanks to us for the presentation. Stay safe and hopefully see some of you all soon. Bye.
Thanks, bye.